Okay, welcome everyone. My name is Jin Huang. I'm an associate professor at the Sydney Law School. Welcome to this open classroom. So this lunch talk is a compulsory ingredient of my postgraduate course, Legal Issues in Digital Trade. I'm very grateful for Sydney Law School and the Asia and Pacific Law Center to support me to open up the classroom so people in the communities who are interested in this topic can join our discussion. And today we have three prominent speakers to discuss from a very diverse point of view to explore the issue of cross-border data transfer, especially in the context of data localization and data sovereignty. So let me introduce our speaker. Our first speaker is Professor Peter Leonard. Peter is a professor of practice in University of New South Wales Business School. Peter's career as a business lawyer has focused upon advising data-driven businesses. This work has spanned merger and acquisition, joint venture, data commercialization, information governance, data protection, protection of trade secrets, and competition law. It's a very rich portfolio. And today, Peter will look into jurisdictions in Asia Pacific and cover the drivers for cross-border data transfer and also the measures against cross-border data transfer. Our second speaker from India is Assistant Professor Ramani Garimella. So Ramani, thank you very much for joining our talk. I understand it is very early in India. Ramani specializes in commercial transaction, especially with a cross-border feature. So she also has a lot of publication in conflict of law, focusing on the conflicts of jurisdiction applicable law, especially in terms of data transfer and the protection of privacy. Remy today will discuss the data protection and data transfer and the service found in India and the relevant protection and relevant measures for data localization and data sovereignty. Our last speaker is David Marcus, who is the head of privacy for Asia Pacific at State Street. David advises all business units on privacy, data security, privacy by design, breach management, and new technology. Today, David will contribute to our discussion from a practical perspective from the private industry, especially, and I think really fascinating is David will provide us with the takeaway practical 5 tips regarding cross-border data transfer. Okay, now let's start with Peter. Yes, Peter. Yeah.
Lovely, thanks, Jenny. And hi to everyone. I've sort of taken my brief today as being to sort of descend in the helicopter from the range of data localization issues to try and give you some taxonomy of the data localization debates that are running today and a way of thinking about how those debates are relevant, particularly to Australia. And I've sort of somewhat tongue-in-cheek, I've headed my my notes that I'll be presenting on and which will be available after this talk as data localization beyond the Beltway, Brussels, Boris and Beijing. And I've deliberately, as you can see, chosen the subject matter to get the alliteration on the B. But it is quite deliberate because, in my view, much of the writing about data localization today is far too focused on the transatlantic data privacy war, which you might characterize as Brussels versus the Beltway, or the Beijing Beltway digital trade war, which you might call Beijing versus the Beltway. The debate that has had the most focus this year, largely I think because of Schrems II, has been the regulatory balance between protection of personal data about data subjects and accommodating access to personal data by law enforcement and national security agencies, and as the Europeans would see it, the appropriate controls that you need over that access through involvement of judicial process and application of principles of lawfulness, reasonable necessity, and proportionality. And that debate has principally been around developing human rights jurisprudence, largely out of the European Court, not textual interpretation of data privacy instruments, i.e. the EU GDPR, the e-privacy directive, or the national EU member statutes. The US-Europe divide deepened through 2020 through firstly the impact of the CJEU's Schrems II decision on the 16th of July 2020 and the US regulator's joint response that was published in September of this year. And then quite recently, the CJEU's 6 October 2020 decision in the Privacy International and related cases. And that decision was to the effect that EU law precludes national EU legislation requiring a provider of electronic communication services to carry out general and indiscriminate transmission or retention of traffic data and location data for the purpose of combating crime in general or of safeguarding national security. So that 6th October decision was really like the domestic EU analogue of the Schrems II decision, where in essence the US regime was found wanting because it didn't have the protections expected by the European Court on law enforcement and security agency access to personal data originated out of Europe, and in particular didn't require application of the principles of lawfulness, reasonable necessity, and proportionality. And of course, the other factor that has happened this year is what I would characterize as a breakdown in international trade law and regulatory norms that's associated with, and I'll put it in my terms, United States isolationism and exceptionalism, partly driven through the views in the Trump White House and partly through US policy alignment to the Californian situs and interests of the US digital giants. In any event, the way the human rights jurisprudence debate develops is that it really centres on the accountability of an EU data controller to ensure, in the case of any cross-border transfer of personal data, that data controller enables or permits is to a final destination jurisdiction that is readily ascertainable, i.e. you can actually work out what the final destination jurisdiction will be. It's not just out to some indeterminate place on a global cloud. And secondly, that final destination jurisdiction has practical regulatory equivalence to the data privacy regulatory controls safeguards, enforcement mechanisms, remedies and sanctions of the jurisdiction of origin, in the case of shrimps, to an EU member state. Now, of course, this jurisprudence has a direct Australian analogue in the regulatory interaction of APP 8.1 and Section 16C of the Privacy Act 1988. And these provisions create an obligation for an APP entity to take such steps as are reasonable in the circumstances to ensure that an overseas recipient does not breach the APPs, and this is sometimes called the accountability principle. And secondly, under Section 16C, vicarious liability of the data exporter if the overseas recipient engages in an act or practice that would be a breach of the APPs if the APPs applied to the overseas recipient. So you can see the analogy there to the thinking in Europe around accountability of a data controller and regulatory equivalence. But however, the analogy breaks down in Australia because the Privacy Act permits the APP disclosure to comply with other laws that are required or authorised by a provision of an Australian law, and permits an overseas recipient to comply with requirements of a foreign law without actually analysing the nature of that foreign law. In other words, there is in Australian law no human rights-based equivalence requirement or balancing of privacy interests of individuals against other legal requirements at either the Australian origin or the foreign destination. And interestingly, on this basis, Australia would fail the Schrems II test, just as the USA did, even though, and unlike the USA, Australia has a reasonably serviceable national data privacy law. However, this data localisation debate, like many debates in the fragmented world in which we now live, is a case of where you stand depends upon where you sit. And too often the data localisation debates in Asia, and there are many of them, are viewed through a distorting prism of data privacy and surveillance waves on the Atlantic Ocean. And the Israeli historian and academic Yuval Noah Harari recently put it this way when he was interviewed in Athens by a journalist from a Greek journal, and I'm quoting from Yuval now, quote, "In the 21st century, to make a country a colony, you don't need to send the tanks in, you just need to take the data out. We are now seeing a new form of imperialism. You can call it data colonialism. It is all about the data." Just imagine a situation in Greece, and remind you, he was speaking in Greece at the time, in 20 years when somebody in Moscow or in Beijing or in Washington has the entire personal data of every politician, every journalist, every judge, every military officer. They will know your entire medical record, your problems, your past diseases. They will have knowledge of your entire sex life and of anyone you knew in the last 30 years. They will know every bribe you took, every joke you ever told about a group or a minority. Will Greece ever be an independent country in such a scenario, or will it be a data colony? And this is, of course, the data sovereignty justification for data localisation laws. That justification sometimes appears in the Indian discussions around data localisation, and I think to a lesser extent in China. In China, it's usually repackaged up as a concern about protection of sensitive data and national security. But in any event, whether it's packaged as national security or as data sovereignty, it has little, if anything, to do with human rights jurisprudence. So it's quite a different debate to the debate happening across the Atlantic Ocean. So adopting a broader lens, the policy justifications given by national governments in Asian jurisdictions for data localization requirements are quite diverse, and they include national or data sovereignty, law enforcement concerns, ensuring access of local law enforcement agencies to data if and when required, concerns as to national security and access of foreign powers to sensitive information as it's expressed in China. Sometimes it's expressed as a desire to build local data warehouses, data farms, data processing capabilities. So it's a stimulation of local industry concern, and you hear that most particularly in Indonesia and in Vietnam. And sometimes it's to do with providing assurance as to the health and safety of citizens, as for example in the case of health information in Korea, South Korea, and sometimes as expressed in Australia. So in short, in Asian jurisdictions, there's been a variety of drivers for mandated data localization, and often the primary driver for data localization requirements has been other than data privacy. And that's a key factor, I think, as we look forward. The other factor I wanted to raise is that in response to global trade and security tensions, we are starting to see the data localization and data sovereignty debate creeping in Australia. And recently the government published a paper addressing national security requirements and national infrastructure and sensitive data. And it didn't go so far as to require data localization, but it did propose new data security requirements to apply to 9 new sectors, being banking and finance, communications, data in the cloud, defence, education, research and innovation, food and grocery, health, space and transport. So in other words, the data localization debate has now come to Australia as a data security debate, just as it has arrived packaged in different forms in different Asian jurisdictions. And Jenny, that was my opening remarks. So back to you. Thank you.
Thank you very much, Peter. Yes, you know, actually just now in the morning, I discussed the shrimp case with my students, shrimp 1 and 2. And yeah, I totally agree with you. The privacy concern is really a big issue for transatlantic. But the trans-Pacific, the picture is very much mixed, right? With China, Australia, India, and Vietnam, you know, privacy or human rights is less than concern, maybe less than concern, you know, compared with the development of industry and the security issues, and the security, maybe the data security or the national security more broadly. Yes, thank you very much, Peter. And for audience, if you have questions, please do not hesitate to put on the chat function. Our speakers will answer them at the end of the 3 presentations. Now, Rami, it is your floor.
Yeah. Good morning. Thanks, Peter, for setting the tone for this discussion. I would like to take it into a little more critical space. You know, I would really want to bring it into the critical perspective, especially because I come from a jurisdiction where these terms are just flowing around and often used as alternatives. So I'm just wondering, you know, how these terms like data sovereignty and, you know, the data governance and, you know, the idea of data localization and things like such have actually come in when in a manner that they are actually used in a very, you know, so one as being as similar to other, if not the word same, right? So I don't think we have, in India, we have actually come to terms with understanding what exactly do we want to achieve when we set out to talk about data governance. I would just like to give you a couple of instances which are contextualized in COVID, but actually raise very serious questions as to what we understand by data and what we understand by the idea of data sovereignty. Now, while the entire world is actually, surprised by the fact that one small Indian province has been able to manage the first, wave of COVID very well, using excellent contact tracing and all that. And I believe this was also discussed in one of the, in the UN. There have been a couple of interesting issues that have come up, and also issues which could lead to severe, very intense policy discussion. Now, I don't know if it's still available or the state has actually taken measures to take it down, but the entire flow chart depicting the contact tracing for a particular in COVID infected person has been uploaded via Google Docs, and the access to this particular Google Doc, information has been, I don't know if the person who uploaded it has actually made it public, but it is available. It was available till very recently for public, right? So I could basically know from which part of the world this particular infected person came in, and till the time he was actually quarantined, I could know at every place where he has come in. So for example, if he had purchased a bottle of water, I would actually know at which point of location he had actually purchased that bottle, he or she had purchased that water bottle, right? The Uber driver, every point of information was actually made available for anyone to access, whether they came within that geographical location or not. The second instance that is even more, I found it a little, of more of alarming was a particular government official on an everyday as an everyday activity released the information of people belonging to his geographical jurisdiction from an unverified personal Twitter account. So basically, I would actually know, if I checked his Twitter profile, where has the person come in from, the infected person coming from, and in which location of the particular province is he there. So, except the name of the person, the number of persons he has come into contact with, and what is their relation to that first infected person, the zero patient, the zero infected person, and the number of persons he has come into contact, and what is the relationship between these people. All that information has been made available on an unverified Twitter account by a state official, no less than the head of that particular district jurisdiction. The administrative official, the senior most administrative official of that particular district, which is one of the basic unit of provincial administration in India, he actually released it, and all this information is available. Now, I'm coming from a country where the social fault lines are at a very dangerous scenario right now. So how actually do we understand the release of this information? Because nobody has consented to that release, right? So that brings me to the question, who actually has the control over this information? Number one, and even more important, actually who owns this information? Do I own an information about myself? So when you use the term data sovereignty, I would really like to know here who owns this information. Now this question has become even more nuanced, because a couple of months ago, one of the major constitutional courts in India has actually given out a decision in complete disregard of a contractual clause wherein the jurisdiction has not been vested to India. No Indian court has had jurisdiction according to the contractual provision, but yet the Indian court has exercised jurisdiction, and its decision was in complete disregard of any kind of a dispute resolution mechanism that was placed in the contract. Now, the reasons that were given was that data is a public asset, and over the public asset, it is a public trust. The government holds the sovereignty over it because it's a public trust. So here I am seeing issues of data sovereignty, data governance, and the right to contract interacting with each other in a manner that we are not even able to locate answers for these fundamental questions as who owns the data. Right? Now, every piece of regulatory instrument in India which talks about data also has something related to the word consent. So they have a consent, but then does consent actually means that the individual owns the data? But if I were to take that understanding, then the new data protection regime that the government of India has introduced in the parliament, I really do not have an update whether this has actually been enacted, but the regime actually promises something called a data fiduciaries. Now, these are the guys who will decide upon, these folks decide how to use the data. They have control over over decisions related to the purpose of data handling in any given scenario. If they get to decide, then is this consent that I have given for the collection of data also to be used as a consent for the usage of data? Now, this is again not very clear. And if this were to be the scenario, then what is the way in which these data fiduciaries can act? Are they responsible to the individual, or are they responsible to the state? And what exactly is the delimitation of this trust kind of an understanding is also not very clear in India. Now, what do we have as of now till the new data protection law comes in is this understanding that there is an information technology regime which prescribes a whole lot of restrictions and on usage of data by body corporates. Now, this is again more of a penal provisions kind of a legislation rather than a legislation that actually talks about data protection per se and privacy per se. Right? Privacy is not an issue that has been addressed within the data protection, within the Information Technology Act and all the rules that were issued in it right from the time. Now, this legislation on information technology, it's about 20 years old. And there have been amendments to it. The first amendment tried to talk something about e-commerce regulation and all that. But after that, we had some more amendments and then the rules released, which talked about, how better we can actually protect the, I won't say protect the information vis-a-vis the individual, but it was more talking about the liability that could be imposed upon the corporates with regard to whatever provisions that were mentioned there, right? But the word privacy and data privacy is not actually defined in any of these. So where does data privacy come in India? It comes from the fact that we have a constitution which talks about a right to privacy. So we have a right to data privacy by logical extension. But essentially, the delimitation is not very clear because the delimitation would actually force the state and the institutions of the state to come and explain what is data sovereignty. So because of the fact that this data sovereignty is not explained, so we don't have something called a data privacy. But what we have is a right to privacy, which can be understood in the terms of the digital world. But one thing that the law has done for us, and that too thanks to the judiciary, is that we also have something called the right to be forgotten. So that's one feature where we have matched the other jurisdictions, at least with the presence of a right to be forgotten. Right? The contours of it have not been tested as yet before the court, but then it is clearly recognized that there is a right to be forgotten. Now, I have shared the link here in the chat box, which actually talks about, the new e-commerce policy that is now in the discussion space with the government of India. Now, the government of India has released this new policy specifically addressing the idea of e-commerce activities that India has become a major hub to. Right. I'm told that most of the IT and the IT-enabled services that India offers actually are in the space of, are majorly handling the data that comes into India, in the sense that it is handled by people in India. So there has been a lot of pressure coming in from the European and the American part of the world, where the pressure was largely coming because we didn't have a serious data protection law. So many corporate entities that are handling this, there could always be a risk of exposure because many of them are working not directly as part of the contract, but there are many subcontracts that come in. So most of the time, the Indian entities are actually handling this data through not direct contracts, but they're coming in through subcontracts. So a subcontract and the kind of liability that could be attributed to this 2 stages or 3 stages removed data fiduciaries, or rather data handlers, is a question. So to address all these, the government tried to bring in this e-commerce policy, but the problem that we had faced was we were unsure about the kind of model that we wanted to adopt. So this policy was preceded by a certain, a commission that was appointed by one of the former members of the Supreme Court of India. So this particular committee actually went ahead and tried to understand the data governance across the world. And of course, the GDPR was its best model that was perceived. But essentially, the GDPR also had another purpose behind it, and that is with regard to harmonization of the law in European region. Now, India started from a rather clean slate because there was nothing for us to understand. So we are really not sure whether GDPR alone could be the best model for us to replicate in India. Probably we could draw a lot of inspiration from them to understand the liability of the third parties and all that. But we have difficulty in, I think we needed to look beyond the GDPR, but unfortunately, this policy is actually not doing that. It's more connected with, trying to find whatever is good in the GDPR and then place it here, wherein it matches what Indian government wants it. Right. Now, when I say Indian government, I'm actually flagging the idea of the government here because we really do not have a kind of, the sovereignty of the individual over his data is not very clear in India. So while I am the data principal, in the sense that the data is actually about me, I am the subject of the data, but I am not sure whether I own the data, because apart from giving consent, I may not actually get to decide the purpose of the data. Now, the problem here is, while we all understand that the state as a sovereign institution should get to decide that, we understand the sovereign role. And I'm sure many jurisdictions also have it, especially with regard to law enforcement and all that stuff. But in India, we have gone a little further here, and we have not really in clear terms identified what exactly are these data fiduciaries doing and to what extent they can do. So for example, if I try to purchase, what do I call, an insurance plan for my vehicle, for my car, right? They can ask my unique identity number. Now, why would they need my unique identity number if I want to purchase an insurance plan? Now, this insurance plan is not being purchased from the state or any of the state-owned corporate entities. It's being purchased from a private entity, a business, a hardcore corporate entity selling an insurance plan. So if I want to use the insurance, whatever amount I have paid for any kind of a purpose for my vehicle, I still have to furnish these numbers. So how do I assure myself that these numbers are actually going to be safe in those hands, right? Now, the other thing is there is something called a permanent account number. So in India, we have these multiple databases that have been, and there is a new database that is being proposed, which is called the health database. Now, there are many, most of India, and especially this pandemic has actually proved to us that our state healthcare is in shambles. Right? Most of the health services are being provided by private entities. And if they have access to the data, right, how is it going to be used? Forget about misuse. I wouldn't even know or have control over its use. Right? So I have, again, the government, when it brought out this policy that I have listed, it just went ahead and it thought that everything about e-commerce can be regulated only by having the data located in India. Right? It's a wonderful, if you want to have a business of data localization, we should go ahead and do it. But then we also need to understand how data localization can actually be achieved in India. Right? Can we achieve a data localization through location? I mean, can we achieve access and security, both assured for all the stakeholders in any one given transaction, only through data localization? Well, we are really not sure if that is a good business decision. What are the economic aspects of it? Now, this is one thing that we need to understand. When the GDPR was drafted, they also considered the costs and the economic aspects of data localization. Whereas in India, I don't think we have given much thought to both the costs and the economic aspects of having data localized in this country. And localization of a data in this country where we have no clarity with regard to the data fiduciaries, the guys who will be having, the folks who are actually going to handle these things. And by just saying that you will be having a privacy policy, I don't think we are going to achieve much value with regard to data security. So we need to assure ourselves first with data security. At least I would think that that should be the starting point before we talk about data localization as a policy. I think I rest my case here because Dave is going to, try to talk about it, take it forward. Thanks, Jen.
Thank you very much, Remy. I really love what you say, does consent means individual own data? In some jurisdiction, the answer is yes. In some jurisdiction, it's no, as I think China is no. In some jurisdiction, maybe unclear, as you said, India. Especially, this challenge the private contracts between technology service providers or the service providers. And I think India is a very important, a country which receive a lot of outsourcing technology, data protection works, okay? Yeah, the uncertainty, unpredictability for private parties. Okay, thank you very much, Remy. Now it is your turn, Dave. As I understand, you are going to discuss from the data industry private party. So please.
Thank you very much, Jean. Thank you, Professor Ramani, and thank you, Peter, for those really, really useful introductory remarks, first stepping us through the drivers and then the sort of jurisprudence and legal issues. And I think what I wanted to do is tackle some of the solutions. Before I do that, I just want to say that I think India is a really fascinating case study. And the reason it is very much at a junction. So if we look at the region, and you know, it is a very dense region, as all the presenters have established today. One of the key messages, you know, if you try and carve up the region, is there's a very much regulatory divergence approach when it comes to some of these issues around digital sovereignty. And when we formed this panel and when we titled it, this is why we are discussing these issues, because we are very much in this melting pot regime. What I've attempted to do on this slide, which I will be sharing with the participants, is to categorize these challenges. And this isn't meant to be a definitive list, but it is meant to be a trigger, because especially when you're in the private sector, it is very challenging to understand the nexus between government, private sector, and third parties. And this is essentially an attempt to bring those learnings together. So what do I mean by this categorization tool? It's something I put together to try and get my head around, you know, what do we need to be doing with all these countries with different regimes in place. So if you look at the model, categories 1 and 2 in the model are probably the safest havens, I would say, for cross-border data transfers. And the reason I say that is they are very much the early adopters of privacy frameworks in the region. So category 1, very much adopting the 1980s OECD guidelines. So, you know, there's a lot of talk about GDPR, but we really need to think about what was out there before the GDPR. And, you know, the unifying framework was very much the OECD guidelines. And I think, you know, if you look at Hong Kong, Australia, Japan, New Zealand, we can see that with the very robust regimes, with very, very clear guidelines, which take us through the scenarios. As Peter mentioned, you know, the Australian Privacy Principles 8.1 deals with cross-border data transfers, very similar data protections in the other regimes. And then, of course, category 2 is moving towards the consumer competition side and putting the consumer at the heart of cross-border data transfers to increase competition. So here we've got Singapore, South Korea, and the list goes on. And I would argue in my model that we're actually in this junction, and it's very fascinating to get Professor Ramani's comments. We're experiencing a category 3 sort of proliferation, if you like. And the reason for that is it's a post-GDPR harmonization attempt, which is actually looking at sector-specific rules. And a lot of the time when we look at sector-specific rules, what we're doing is based on the security of the data and based on where the data residency needs to occur. And this is why we find ourselves in this debate today, you know, in this situation, which is what do we do about these localization rules? So I would say the cross-border data transfer rules become a little bit more complex when we start hitting the category 3. And they are even more complex for category 4, where you have no rules whatsoever. And we see that with some, you know, areas around APAC that haven't adopted any privacy rules as well. So I think if I turn now to my area, which is, you know, setting out, and I think we addressed this, do we really need to make sure that cross-border data restrictions are in place? What is the basis of it? And Professor Ramani rightly pointed that out. You know, what's the point of these localization rules? And I think if you look at the trade implications of limitation of data, they are massive. So, you know, recently the ASEAN digital governance framework looked at, you know, this idea of making sure that members don't block access to cross-border data transfers. So, and they very rightly pointed out that you don't need to limit cross-border data transfers because it's got nothing to do with the economy. So this idea, this misconception that somehow limiting or localizing data is in the economy's interest, that really needs to be looked at very carefully. And then of course we've got gaps, and under World Trade Organization law, the issue that we run into is that countries who are members of those agreements need to make sure that they are not having in place disguised restrictions on trade and services. I would argue that data localization and imposing digital sovereignty is one of those disguised restrictions, and we need to make sure that it's not, continually being sought where it causes issues for cross-border data transfers. In the interest of time, I might push forward to some of the challenges that you might face in the private sector. So of course, we're moving data to clouds. We're also moving data to servers. And the issues that creates is sometimes the cloud itself is in a de-territorialized zone. So, you know, we talk about shifting data from the US to the EU, as Peter mentioned, under the EU Privacy Shield, which is now invalidated. But what about the cloud? The cloud sits, you know, in this almost a de-territorialized space above the jurisdictional zone. So this then creates further complexity, because we're not just talking about the sovereign state concerns, we're also talking about sovereignty over something which is not part of a territory, which I don't really have the answer to that, and I don't intend to address it, but it's certainly a very interesting issue. And here we are back again talking about the India case study, which again I think is very fascinating. And to touch on the points that Professor Ramani made, you know, India is category 3 under the model that I've proposed. And the interesting thing about India is a lot of global companies obviously use India as a hub for data processing, data storage, via IT and software offerings to its clients. So, I mean, it shouldn't be a surprise that we are sending data to India. The surprising part is, you know, it's a category 3, and it's come late to this debate on how to provide sufficient rules for cross-border data transfer. So obviously we've still got a privacy bill which is being debated, and it has been in play, being debated since 2018. So we're hoping that there will be formality on the process. I think that the interesting thing to pick up on the comments of Professor Ramani is that there are a lot of localization rules implanted in both the draft bill, for data fiduciaries to keep Indian data onshore, but also in the draft e-commerce policy, which allows audit by government agencies for non-personal data and tax reasons. So you've got a big grab on personal data, you've got a grab on taxation data, and you've got a grab on non-personal data. So it seems like, you know, there's a huge emphasis on localization wherever the data can be localized. There seems to be, at least in the draft bills we're seeing, that seems to be the approach. So here we are at this issue of solutions. What could we think about as perhaps some of the guiding best practices when it comes to this area, given the complexity, given that we've got these 4 categories, at least in Asia Pacific, you know, maybe there are quite a number more globally, and differences in regimes. What could we lean into and rely on to allow us to navigate this complexity? I don't state that this is a definitive list, but I'd like to posture a couple of solutions. And the first, and probably the most, the safest of the solutions, is standard contractual clauses. So standard contractual clauses are the way that you can alleviate, at least between two companies, these concerns around data sovereignty. And the reason you can do that is because you've got responsibilities governing the usage and maintenance and processing of the data. And it isn't just leaving it to domestic law. So in a way, we can use this contractual framework to allow us to, you know, ensure that those category 3s and category 4s are being handled appropriately. I will say this doesn't address the issue of housing data on local servers. If you've got that issue, you can't obviously contract out of it. So this is not a quick fix for that particular concern. The other offering or best practice I can probably provide is binding corporate rules. Now, these are a mechanism under the GDPR. So if we look at Article 40 of the, sorry, I beg your pardon. If we look at Article 47 of the GDPR, there's a requirement in there, or a safe harbor, where you can use binding corporate rules within a very large organization to send data to different branches. Now, obviously, if you're just a Australian domestic or a Indian domestic, this may not obviously be feasible because you don't have branches and offices offshore which you can send the data to. This is very much in line with an offering that suits a multinational company, because within that company you can have the binding corporate rules. It's a benchmark that you can use across all your branches, and the only problem, of course, is getting this registered, so it can take up to 12 months. Very quickly, I offer 5 other solutions which we can pick up in the questions, but the ones that I'd like to take you through, obviously now that Schrems 2 has been invalidated, we don't obviously rely on it in Australia. It's only relevant to EU to US data transfers. But, you know, we could be looking at things like the APEC cross-border privacy rules, the ISO standards, and also learning lessons from the NIST privacy framework as well. And then I'd like to sort of leave a couple of other comments here about active supervision, because, you know, even the OAIC says it's not about, you don't carve it up into whether you're data recipient. So if I had a data recipient in India who's just accessing data but not processing it, it's irrelevant. The question on cross-border data transfer is anyone who receives data. So active supervision of your data recipients is crucial. So, you know, either attending sessions, accessing their servers, making sure you know who their vendors are is critical in this space to ensure that you have the ability to understand and curtail any risks and limit the access to that data. Obviously, we've already talked about consent. It is, under the GDPR, it is not the fix to this area. I would also say consistency. So third parties, employees, clients, everyone needs to have these standards applied consistently when it comes to cross-border data transfer to ensure that you don't have any lapses which cause breaches. I might leave it there and hand back to you, Jean, for any questions.
Thank you very much, Dave. Okay, very informative. Is ready to take away key messages. So any questions? I see there's one question in the chat function, but Ramani has already answered that question. So any more questions? Okay, so let me propose a question. Okay. Actually, Peter, Dave, and Remy, you all mentioned about the private contracting. Especially Dave, you talk a lot about the standard contract clause In the Stream 2 case, the European Court of Justice also upheld the validity of the SCC. But I'm quite interested, actually related to Ramani's presentation regarding an Indian court actually set aside the dispute resolution, the jurisdiction clause in a data transfer contract. According to Ramani, if I'm wrong, please correct me, the Indian court consider the data transfer, the data is the public data, and so Indian court has jurisdiction. So as far as I understand, the standard, the SCC contract in the EU, it requires the compulsory jurisdiction of the EU court, European Union member states court, or the EU law. So I just wonder, you know, in Australia, we may consider it's a consumer contract. The federal court should have jurisdiction. So are there any, you know, is this really my academic, you know, question, or it is a practical question that the dispute resolution clause regarding which law should be applied and which court should exercise jurisdiction may be controversial in dispute?
Let me just answer it from an Australian perspective. I mean, often the issue is resolved in Australia through the application of the unfair contract terms provisions of the Australian consumer law. So regardless of the principles of private international law, the attempt to remove Australian jurisdiction from consumer contracts is unsuccessful. Look, just addressing the broader question of how data privacy laws are relevant in this space, and through that, the restrictions through, or the requirements as to standard contractual clauses. Of course, in some Asian jurisdictions, the issue is not an issue as to personal information at all, but an issue as to so-called sensitive information. So in China, the definition of sensitive information is much broader than the definition of personal information. So part of the problem in, again, applying GDPR type models in this space is that for many Asian jurisdictions, the concern that they have goes more broadly than the regulation and control of trans-border flows of personal information. The other thing I'd just say in conclusion of my remarks is that we do need to be careful here when we talk about data localization, and I think Ramani expressed it well in that there are a variety of topics that are actually lurking under there. One is, does the law require you to locally process, or does it not care where you process? Is the law imposing a restriction on transfer of a copy of the data out of the country? Is that addressed if you maintain a copy within the country as well as allow a copy out of the country? Or is the real concern to avoid a copy going out of the country because you're concerned about data sovereignty or exposure of sensitive information offshore? Is the requirement to provide local storage, in which case it might be reflective of a policy of requiring development of local industry? Or is it a requirement to provide local access to data, so you don't actually care where the data is, so long as you're able to serve legal process on an entity within the jurisdiction without having to go through MLAT or the other complicated international procedures for cross-border execution of legal process? So data localization is a convenient term to describe what are in fact a wide variety of laws, and we just need to be cautious in using these omnibus terms and cautious in taking concepts out of data privacy laws into other areas such as sensitive data.
Thank you very much, Peter. Yeah, I think it's really important. What's the meaning of localization, right? It is quite a comprehensive one. What does it mean? Yeah, yeah. So any other comments? Yeah, so we have one question here. So let's just adjust the question and we close up. So any comment on data transfer linked to international border information? Australia has a strong business protocol of sending commercial data to offshore centers for processing. So any comments on this? I guess let's go back to you, Peter. Okay. Or Dave, do you have any comments?
Yeah, I might make a quick comment. I think that's definitely what we've tried to tackle with you know, the solutions focus. But if I think about what more both the private and the public sector can be doing, so it's not just about standard contractual clauses. There's a whole range of you know, options available. I think one of the things that we need when sending data across is very clear white lists which governments release, and that way we can know which jurisdictions are green lighted and which present problems. So if you're an Australian company sending abroad, you know, I would be hoping that there is ability to look at some of those white lists. I think the other thing that we need is reform, not just from privacy, obviously, as Peter mentioned, but from all angles. So I mentioned WTO reform, you know, looking at buttressing the GATS principles, and we need more frameworks globally. There's also digital governance within ASEAN. So perhaps that is a good opportunity to tackle some of those category 4 countries.
Okay. Okay, thank you very much. Thank you very much, Peter, Remy, and Dave, you know. Also, thank you for everybody, your questions and your stay, you know, you bear with us, you know, throughout this 1 hour. Thank you very much. Bye-bye. Have a good afternoon. Bye-bye. Bye-bye.
Thanks, everyone. See you later.
Yeah.
Bye.